The legal issues having to do with a disabled person include not just the financial issues, but also making personal care decisions. Because I'm an elder law attorney, and most of the cases I have are having to do with elders who were competent at one point, and they weren't born disabled, and they can make decisions for themselves earlier on. We're going to look at what are the decisions, who's going to make decisions if they become incapacitated, and can we put in place the different kinds of things. I talked about a conservatorship. A limited conservatorship is a developmentally disabled person. If they have no documents, maybe they have very little money, but someone is going to go and get appointed as a limited conservator for them. Limited means that the powers that the person is given under the California law will be tailored to the abilities of that disabled person. Again, a developmentally disabled, maybe an autistic child, does have ability to make some decisions for themselves and handle some things for themselves, but maybe not everything. So we're going to have a limited conservatorship. Financial affairs, if the person was capable of signing powers of attorney, trusts, prior, then we're not going to have to go into the limited or full conservatorships if once they become incapacitated, unless there's a fight in the family or they just don't believe that they're incapacitated and won't let you handle. Okay, I'm going to talk a little bit about benefits. What are the benefits out there that can help pay for care? Unfortunately, there's only really two benefits. They're major benefits that can help pay for care for an elder. And I'm here to talk just about elders. I know we talked about developmentally disabled and younger folks, but now I'm going to be talking about elders. So if someone is 65 or older and they were a veteran or they're the surviving spouse of a veteran, they may be entitled to VA benefits. The VA benefit that most of the time we're talking about is a VA benefit that is paid to a veteran or the surviving spouse who served during a wartime period. World War II, Korea, Vietnam. We started the Gulf War in 1990, and we've never not been at war since 1990 under the Congress. And these are the wartime periods as defined by Congress. The wartime periods, if we have a veteran who served during a wartime period, all they had to be is on active duty in the military at least one day during the wartime period. They had to be on active duty a total of at least 90 days. But if we can qualify them for the one day, they pretty much always satisfy the 90 days. Where wouldn't this happen? You might have someone who was in the reserves that was called up to active duty, and they were in the active duty for a snippet of time, maybe just 60 days, and then they're back because they weren't really needed. Guess that could happen. But I've never had a situation where someone wasn't in at least 90 days when they were in the military. You have to have been discharged other than dishonorably. So a dishonorable discharge will disqualify you for VA benefits. However, there are situations in the past where folks were discharged dishonorably that shouldn't have been. Someone might have been gay and they were discharged dishonorably. Nowadays, you don't get a dishonorable discharge for that. So you can get that changed. Perhaps it was because they acted out badly. They got into fights and all those kind of things. Maybe they were suffering from PTSD. You know what that is? Post-traumatic stress disorder. Now we know a lot more about that. So that might have been the reason that they were bad when they were in the military. If you can prove that, and sometimes they can get the discharge changed. So a dishonorable discharge is not automatic that they can never get qualify for benefits, but they'll have to go through the effort of trying to get the discharge changed. In addition, let me see. In addition, okay, here's it is. The 90 days or the surviving spouse of a veteran who served on active duty, 1 day of which during a wartime, other than dishonorable discharge, I'm going to skip this a second. You must be 65 or older or 100% permanently and totally disabled. We're not talking about a military disability here. That's a different benefit. That's called compensation. So if you leave the military and you had your leg blown off, then, or you lost your leg in an automobile accident, it doesn't matter how you were disabled if you were in the military. It is the fact that you were on active duty and you got disabled. There, you're entitled to compensation for the rest of your life. And so that's a military disability. This 100% permanently and totally disabled is a person whose disability has nothing to do with military service. Maybe they were in a car accident when they were 45. Maybe they were in a skiing accident when they were 30 and they became disabled. If they're 100% permanently and totally disabled, then they can get this benefit. Most of the time, we're talking about elders who are 65 or older. There are currently 3.8 million Americans who could qualify for this benefit, either because they were in the military or they were they're the surviving spouse of someone who was in the military and they're over 65. So this is not a few people. If you qualify for, here are the wartime periods. I think we'll just skip this. If you, I don't know if the materials you got have a copies of my slides, but if you'd like this, you can get it, or you can Google the VA wartime periods and you can get it from lots of sites. Why do we do this? Yes, sir. I'm coming to that. Why do we do this? How much money are we going to get from the VA? If the person will qualify for full benefit under it, if it's a married vet who needs aid and attendance, I'm going to be talking more about that, they can get $2,019 a month. That will really help with caregiving costs. If it's a single vet who needs aid and attendance, they can get $1,703 a month. If it's a surviving spouse who needs aid and attendance, they can get $1,094 a month, she or he. I skipped over this one because it needs a little more explanation. In all of the other cases, it's the person who's making the claim that needed the aid and attendance. If it's a married veteran, and the veteran themselves does not need aid and attendance, it's his or her spouse who does, then the veteran can make a claim for $1,337. Aid and attendance is a supplement on top of the basic pension. It's called a pension. It's not really a pension as we know it, like when you retire and you get a pension. That's just what the military has called this program for decades and decades. But if it's the claimant, the person who's making the claimant has to be making the claim has to be the veteran if the veteran is living. If the veteran is not living, it can be the surviving spouse. But until the veteran dies, the surviving spouse is not the claimant. And it must be the claimant who needs the aid and attendance in order to get that as a supplement. So aid and attendance is a supplement to the basic pension program. The pension program has the financial issues to it.